Started recording. So yes, it is 5 o'clock. So I'm going to start. This is the last webinar. So this is the third webinar of the three that we had. And I think by now you are almost as clever as I am, some maybe even more clever because you are in practice. But yes, we've come a long way. So yes, congratulations to all of you who are still hanging in there and still doing your best. So first of all, you know that I am Martha Slabbert, and by now you know Bonnie Venter, who does all the admin and the marking of the portfolios, etc. Remember that for administrative matters, you must still contact Grace. We will try to assist with other matters, but Grace ultimately is in charge of this whole module. As I've said, we've done two previous webinars and it is on your website, the PowerPoints, not the recordings. We do not make the recordings available. That is a decision from the Law Society. So today I'm going to focus on the last part of the work. Last time, the middle one, the second webinar, was the most important one because that actually touched on medical negligence. I've added there my email address just for those of you who would like to send an email to me personally, who would like to ask something or ask a court case or whatever. You're more than welcome to contact me and I will try to answer as soon as possible. And if I do not know the answer, I will try to find out and come back to you. And then just another remark, there are practical exercises in your study material, but we do not provide the model answers as every case differs and every person's way of handling a case will also differ. Okay, then see the announcements regularly. Today, I've also asked Bonnie to put some interesting information under announcements. I don't know whether she does it under announcements or extra study material, but it is there on the website. So keep an eye there regularly. I will also, after I give the lecture today, I will send her the PowerPoint and she will post it on your website. And then the second portfolio is due. So I just ask, do your best. I've seen your results for the first portfolio, and I must say I am more than impressed. Your work is excellent. The average for the group that I have just calculated myself is about 85%. That is beyond excellent. I went through all the marks and I saw that many of you got full marks and others got 148 out of 150 or 146. As I say again, be proud of yourself. Be absolutely proud of yourself because we give you very little information. We basically expect you to do all the work. And then if you get that good marks, then feel really happy for yourself and brag for your bosses and say that you are doing very well. Just remember that you are also welcome to make comments. If you find the work too easy or you didn't learn anything or it didn't contribute anything, then of course you're also welcome to make comments like that. As I've said, I am nearer to 100 than to my birth date, so we can take criticism and we can just learn from that. So indicate to us whether it was meaningful or not, the cases that were prescribed. Okay, just a summary of where we end last time, and that was how to approach a medical negligence case. In other words, where do you start? So I'm just summarizing what I said last time. So first of all, you consult with the client and you gather all the facts. And I've said to you, you can either ask the client to give it to you in writing, you will send the person home and he or she must come back where they have written out or typed out everything that happened. or you can orally speak to the person, make a recording or make notes. But while you listen, then you check in your head whether there is a cause of action. And remember, you also check the elements of a delict, whether all of those you will be able to prove. And what are they? It must be an act, it must be wrongful, there must be fault, and there must be damages. That's the most important now. Can you believe it? My mind gets stuck. But you know the requirements for a delict. The biggest problem that you must, or where the challenge will be for you when it goes to litigation, is to prove causation. Fault will more than always be negligence, because
bezifakiwe court then kwaphuma i-directive
laat ek net gou kyk.
i-Grahamstown le directive
Kwempe,
yenze i-order ethi
Mr. Kwempe, please switch off your microphone. Yeah, just mute
okay.
your microphone.
Where is my, okay there.
There to the right, top right of your computer. Do you see it? A little microphone. Just click on it, then it goes.
Mute. Yeah, it says now my computer is muted.
Yes, it's muted now. And switch off the camera.
Hear me now.
Let me just
Can
see.
You see?
Sorry, I'm just seeing here. Let me see. I'm going to mute you. Yes, I'm going to mute all of you. Okay, I've muted you, but switch off your camera as well. Otherwise, it takes too much data. You can switch on your camera again when you speak to me or when we interact later. So in the top right-hand corner, you will see a little camera. If you click on that, then you will switch off your camera. Okay, so I'm busy talking to that you gather all the facts, and you must in your mind think whether you will be able to prove all the requirements for a delict, that there was an act, that there's causation, that it was wrongful, and that the person suffered damages. Remember, the damages is the most important, because if there's no damages suffered, even though it feels something is wrong, then there will not be a case. So you look at all those things while you listen. And remember, what I've also said is that people remember selectively. So maybe the person, the client in front of you, will only give you 90% of the facts. That's fine. Get as much facts as possible. Then you ask the client what he or she wants. As I've said last time, do they want closure? Do they want revenge? Are they angry with the doctor or the hospital? Do they want financial assistance? Maybe a baby was born with cerebral palsy and there's a lot of costs involved to look after a child like that. Maybe they want that, but ask them what they want, because that will also give you an indication what is going on in the client's mind, and that can determine the way that you go. Once you know that, you start obtaining all the records that you can possibly get, either from a hospital, depending on what happened, the doctor's records, the hospital records, the pharmacies in the hospital, all the records that you can possibly get. Remember, they are not compelled to give you the original, and they will never. So they will give you copies and you will have to pay for it. But also remember, sometimes either out of ignorance, negligence, I don't know, sometimes when they make copies, they only copy the one side of the paper. So see to it that the records make sense. So in the case that they only photocopied the one side of the paper, go back and ask for the other side of the paper as well. In other words, the records, what the doctor wrote, what the nurses wrote, what the pharmacist wrote, all of that together must form a picture. And then you remember what the client told you, and you look at all of this together, and then you will see whether there is a possible case or not. So you compare the hospital, the doctors, the pharmacist records with your client's version, and then see whether there is a cause of action. Remember last time I've also said that if there was a bad outcome, it is not necessarily negligence. In other words, you went for a hysterectomy, you got infection, you end up in ICU for 7 days, but you eventually survive and you go home. It is not necessarily because of negligence. Medicine is not an exact science, so every person will react differently to an operation or to anesthetics or whatever. And the fact that you stayed longer in hospital than anticipated, all of that is not necessarily negligence. And then always remember, you must have suffered damages, provable damages. Otherwise, there is no case. Then I've also explained to you that in order to win a case or to have litigation in a court, you will need an expert. So the expert will become relevant once you have your client's version and you have all the records that you could possibly get. Then you will take all of that and you will hand it over to an expert. And you will ask an expert. Remember, I don't know who is in the audience, but because it's through the Law Society, I assume the majority of us are lawyers. Because we are lawyers, we might not understand the doctor's reports. We will not understand the notes that the nurses make. We might not understand what happened in the operating theater. So all of this must be handed to an expert in that field. In other words, if it was a child and you need a pediatrician, you cannot give it to a dermatologist because a dermatologist works with skin problems only. So you must find an expert relevant to the situation in front of you. And as I've said in that book of that in the previous one, Lawrenson and van der Heever, they explain step by step how do you consult with an expert. Once the lecture is over and I put on my camera, I will also show you the other book, which I think is excellent. But I've also mentioned you can go to the website of the South African Medico Legal Association, and they have a list of experts, so you can find an expert there. But of course, there's costs. Experts does not come cheap. Just as a matter of an example, we once in a case used a psychologist for an expert opinion. The opinion was about, I think about 8 pages, and the cost was 63,000 Rand. So experts do not come cheap, but you cannot litigate without an expert. Why? Remember, what is the test for medical negligence? Whether the person acted like a reasonable doctor in the circumstances. And in order to prove that he did not act like a reasonable doctor or specialist or nurse, you will need an expert in that same field to come and testify and say that what has happened is not the ordinary procedure, etc. Okay, so once you get your expert opinion back and the expert indicates that something went wrong, and according to him or her, remember, an expert is allowed to give an opinion. So the expert will give an opinion whether he or she thinks there was negligence, or whether he or she thinks it is just something that it is a risk associated to the procedure and nothing really went wrong, and he doesn't think that you will win the case. So that will give you a very clear direction or indication whether to proceed with the case or not. If the expert's opinion is that there is cause of action and he or she thinks that the doctor or surgeon or nurse or whomever did not act like the reasonable doctor, surgeon or nurse, then you start preparing your documents and then the process starts. So you issue your summons, etc. You then start with the practice part of the whole thing. And remember, you need to indicate whether you are planning to litigate on the basis of a contract or on the basis of a delict or on both. You can litigate on both. Remember, right at the beginning, we said the difference between the two. If you claim a breach of contract, let's go a step back. When a patient goes and see a doctor, there is a contract between them. It need not be in writing. A contract is valid even if it is orally. So the fact that the patient went to the doctor, accepted the treatment, there is a contract. So when something can go wrong, you can claim on the basis of a contract, but then you can only claim patrimonial loss, real loss, that you can prove and not pain and suffering. Whereas if you claim and your documents are prepared on the basis of a delict, in other words, the person broke the duty of care and he did not apply the skill and expertise expected from a person in his position, then you will claim on the basis of a delict, because then you can also claim pain and suffering. But nothing prohibits you from claiming on both grounds. And at the end, I will discuss a case where it was done on both grounds. Then you must remember that if it is against the state for a public hospital, you have to consult the institution of legal proceedings against certain organs of State Act, because there are time limits in which you have to give notice that you are going to institute an action against the state. Sometimes the state or the people do not answer, but it's always, if something like that goes wrong and things doesn't happen exactly as it is in the act and as you would like it to go, you can always ask for condonation of that. But you have to remember it, rather preempt that than ask for condonation afterwards. Then I just briefly want to speak about this case. It was a case that you answered in your portfolio. Sorry, I'm just drinking water. You did this case for your portfolio. It was where there was a cerebral palsy, and prescription also played a role. The reason why I asked or prescribed this case is I wanted you specifically to see you as attorneys, lawyers practicing or going to start to practice in medical law or medical negligence, be aware of case selection. And that is specifically what I wanted you to see in that case. In cerebral palsy cases, it is very tempting, and why I say that is because the average claim for cerebral palsy nowadays is anything between 22 to 32 million rand. Remember, if it's cerebral palsy, then something went wrong, but it will depend on the facts. Something can go wrong in utero while the baby's still inside the mother. Something can go wrong during the birth process, or something can go wrong just after birth. So it will be difficult to explain or to litigate in court where exactly did things go wrong. But if you can prove that because of the negligence of either the staff or the doctor, the baby suffered a lack of oxygen, and therefore the baby was born in a depressed state, as they say, and eventually he or she now suffers of cerebral palsy. If you can prove the causation that the negligence led to the cerebral palsy, in other words, but for the negligence of the maternity staff and the doctor, the child would not have been suffering from cerebral palsy. And you win it. And the MEC is 100% liable for all the damages. Then you must prove the damages. And how do you do that? It is the past medical expenses, the future medical expenses, the loss of the amenities of life. In other words, you will get an actuary that will make a huge calculation, and it can then end up, as I say, between 22 and 32 million rand, because it depends on whether the actuary will determine how old this child might be. And this child will need physiotherapist and speech therapist and all kinds of therapists. And all of them will give you a quotation sort of what it will cost over a period of, let's say, 20 years to give attention to this child. And that is why these cases have these huge amounts. Remember, I told you about the DZ case in the Constitutional Court, the Mashinini case. You must look that there's now a change. Nowadays, the courts do not award one amount once and for all. The courts now say that the child must get the services from the public sector as and when is needed, and the money for future income, if the child worked, will be held back, and it will be paid out as and when necessary. So keep that in mind. But now think for yourself. If you take the case on contingency, and it is 32 million. Now, what does contingency say? 25% or 100% of your cost, but not more than 25%. So what is 25% of 32 million? It is quite a bigger amount. Therefore, it's worthwhile to litigate these cases. But I wanted you to see in this specific case where the attorneys played a little bit first to see whether it's worthwhile or not. That is not right. That is not ethical. And you should not do that. You should not practice like that. So I wanted you to see the wrong. So don't do that. Do not apply case selection. Treat every case that comes to you equally and decide whether it is worth it or not. But that is up to you. I just wanted you to see that as an example of an attorney's firm who did case selection and then ran into prescription, etc. So that was the purpose of that activity. Then please remember that the High Court rules have changed. In the Government Gazette of 7 February 2020, number 43000, Rule 41 Big A, mediation as a dispute resolution mechanism. That became effective or operational on the 9th of March in 2020. What does it mean is that you should first try to resolve the issue through mediation and then indicate to the court that you've tried mediation and that it didn't work, and now you go over to litigation. Remember that mediation is not the end. If you are not satisfied with the outcome of mediation, you can still go to litigation, and the one does not affect the other. I personally feel that it is a good thing to mediate in medical negligence cases, because most of the time, the person who suffered the damage want answers. Now, the insurance of doctors, the Medical Protection Society, they advise their members, which are doctors, everyone registered at the HPCSA, their members, they are advised to say nothing when something went wrong, in order not to incriminate them. But if they realized something went wrong, they should immediately notify their insurance, and their insurance MPS will then act on their behalf, and they will talk for them. And a lot of patients or clients find that unsatisfying. Sometimes all that the client wants is an apology. All that the patient, or let's say the mother of the patient, or the wife of the patient, or the child of the patient, all they want is that the doctor should tell them what went wrong, say they are sorry, explain what they did to rectify the mistake so that they can go on. But it doesn't happen. Most of the time when something goes wrong, the doctors shut down completely. They don't speak, they don't explain, and they definitely do not apologize. And that is because of their insurance. Now, once again, personally, my opinion, this is not prescribed, this is not law, and a lot of people differ from me. I believe for a doctor to say, "Dear ma'am, dear sir, I am so sorry. We tried everything we could, but we could not save the child, or we could not save your husband's leg, or whatever," and walk away. That to me is not an admission of guilt. That to me is humanity. What happens afterwards, and whether there's litigation or whatever, that's fine. But at the end of the day, no person is an island. No one goes to hospital alone. Everyone has someone who loves him or her, who cares about him or her. And if something goes wrong, you want answers. And for the doctor or the specialist just to say something went wrong, I am so sorry, according to me, is not an admission of guilt. But unfortunately, the Medical Protection Society feels differently. And therefore, when something goes wrong, the doctors will not talk. And then when you start issuing all your documents, you will do it through their Medical Protection Society or their insurance. And when an amount of damage is awarded, I'm now speaking private sector, then it will be paid by the Medical Protection Society. And that is why the insurance amount that gynecologists and obstetrics specialists, the amount they pay per year for insurance is exorbitant. And one can understand that, because when the insurance have to pay out the damages, and it's 32 million per case, then it becomes in a certain sense ridiculous. A lot of people or specialists do not want to do obstetrics anymore because of the dangers of being litigated against. Others leave the country, so we are actually in South Africa short of obstetrics. These are the people that deliver babies. But let's come back to mediation. I'm talking a lot. So all of you that has done this course, sorry, I'm just drinking water. You can become an accredited mediator, but you will need to do training. You can Google, but UCT, the University of Cape Town, they do mediation training. Stellenbosch University, they do mediator training. South African Medical Legal Association, they do the training in conjunction with those two universities. It is worthwhile. I did the training. It was 7 intense days from 7 o'clock in the morning until 7 o'clock in the evening. It's intense. You do theory and you do a lot of role play. But I found it extremely interesting. I found it difficult. So this is just personally that I'm sharing with you. Lawyers, our minds are wired in a certain way. The moment something happens, our minds go into what's right, what's wrong, who must be punished, how are we going to punish it. In mediation, you need a much softer approach. So you as mediator do not become involved. In other words, you will ask the patient, what do you want? What is the problem? Why are you here? What do you want from the doctor? And you will speak to the doctor, all in a softer tone, a more relaxed tone than litigation. But at the end, once you master it, it is a lot more satisfying. It was satisfying for me, and I think it is much more satisfying for your client. Because when you litigate, most of the time, it is the lawyers only in court, the attorneys and the advocates. The patient who suffered, who are claiming the damages, need not be in court. So everything sort of happens without him or her being part of it. Everything happens amongst the lawyers, and it's the lawyers and the advocates and senior counsel and whatever. And then at the end, the patient who suffered just hear whether he has won or not and whether he's getting an amount of damage or not. Whereas in mediation, he or she will be part of the whole process. But it is a personality thing. It is something that you yourself decide whether you are built for it, whether you are wired for it. But you can only do it once you are accredited. You need a certificate and a number. And then only are you an accredited mediator, and then you can charge a fee, of course, when you do the mediation. But as I say, go to the website of SAMLA. I think that's a good way to get information, otherwise UCT or Stellenbosch. Okay, so last time we spoke about negligence, how to test negligence, etc. But now let's say you have to appear for the defense. Then what will be your grounds of justification? In other words, you are now not appearing for the patient, you are appearing for the doctor. Then one of your arguments can be, but the patient gave informed consent, or you can argue what you did because there was an emergency. Or you can argue that you did something because there's a statute giving you the right to do that. Or you did what you did because of a court order. These are just some of the grounds of justification. It's not all. These are just some of them. And then when they are present, it excludes wrongfulness in a delict. Remember the elements of a delict, so it will take away the wrongfulness. And when it is a criminal case, as it was that case of Van der Walt, it will take away the unlawfulness. Just note the two words. We speak of wrongfulness in a delict and unlawfulness in criminal law. Then I just mentioned there a few others. You can always argue contributory negligence. You can argue prescription, or of course you can remember the proof is on the plaintiff, and the plaintiff must prove beyond, not beyond reasonable doubt, on a balance of probabilities. So you can just question and at the end indicate that there was no causation. And then, of course, it's for the judges to decide whether the plaintiff has proven on a balance of probabilities the case or not. In a criminal case, then of course you have to prove it beyond reasonable doubt. You are welcome to post questions in the chat box. I will look at all of them once we're done. I'm first going to finish the lecture so that those people who has other commitments can go, but I'm in no hurry. So I will afterwards answer all questions and interact with you as long as you wish. Okay, we have done informed consent, but I'm just reiterating again. Informed consent, when that is an issue, the first thing that you do is you go and find the locus classicus, Castell versus De Greef. And in that case, you will see all the requirements of informed consent. It's an old case, but it's the standing case. It will give you the best guidelines ever. Informed consent falls under the Latin phrase volenti non fit injuria, and that just means he who consents, no harm is done. In other words, if you gave consent, you cannot turn around and say, but I'm going to sue you now because you hurt me or whatever. If you gave consent, but then you must understand what you have consented to. And that is sometimes, for example, you have consented to a sterilization, a laparoscopy, where they will just bind off your ovaries, and then only to wake up and see, but they have done a whole hysterectomy. So you only gave informed consent for a sterilization, but you wake up and there is a whole hysterectomy done. Then you will look at the facts. And if the doctor will then, so I'm just quickly going, let's see if I can. I want to go back quickly. Then you will argue, of course, emergency. That while you opened up, you saw that the uterus were in a terrible state, and in order to save the woman's life, you did the hysterectomy without the specific consent. But consent is one of the most important things that you must remember, and a lot of disputes is around, did the person give consent or not? And the doctors are very, very slack in getting informed consent. And a big wrong that the doctors do is they ask the nurses to get informed consent. And that is actually wrong, because it's the doctor that must get the informed consent, not the nurse, not the receptionist, it is the doctor. But there I just say, go back to your study material and see again the requirements for valid consent. And then if you want to go further with consent, also look at the National Health Act. If it's got anything to do with mentally ill, then you must look at the Mental Health Care Act. Remember, I warned you, very important, if it is a child, you have to consult the Children's Act. But remember, I said a child of 12. There's the cutoff. So don't think the Children's Act is applicable to everyone below the age of 18. Yes, according to the Constitution, a person is an adult at the age of 18 and above, but the Children's Act is exceptional in saying that a child of 12 can consent to medical treatment. Then also remember, concerning consent, the Choice of Termination of Pregnancy Act, that a girl of any age can consent to a termination of a pregnancy under the conditions in the Act. And then also remember the Consumer Protection Act is now also there and relevant when the dispute is about informed consent. Okay, let's go to the next one. Okay, I want to use an example just to indicate to you what it can look like. So let's This is a hypothetical scenario. The Kuneni family has 2 children. John is 8 years and he's healthy. Frans is 6 and he suffers from Down syndrome, but apart from this Down syndrome, he also has other illnesses, like ADHD. He needs a speech therapy, etc. So he needs a lot of attention, and this is financially draining the family. So Francis' parents met an attorney who is an expert in medical law at a braai, and this attorney asked whether tests were done before Frans was born to determine if everything was fine. And then the mother answered, yes, tests were done because she was not young anymore. She was not in her 20s anymore. She was in her high 30s. So she was scared. So she went to an expert, and she told the expert they must do all the tests possible, because if something were going to be wrong, if they saw on the scans or the machines or whatever the specialists use that there's some or other abnormality, she would rather go for an abortion. Okay, so you are the expert. What will your advice be? So just think for a moment, where will you start? Where will you start? What will your advice be? Okay, so let's see. Where will you start? What will you do? What am I testing here basically is the difference between, and we've spoken about that previously, unwanted pregnancy, wrongful birth, wrongful life. So let's evaluate and see. Was it an unwanted pregnancy? No. She wanted to fall pregnant. They wanted a child. So that one is overruled. Wrongful birth? Maybe. Wrongful life? Maybe. Can you remember what is the difference between the two? Wrongful birth is where the parents claim on behalf of the child that was born with abnormalities because of the negligence of the gynecologist to enlighten them about the abnormalities of the child, because they would have aborted the child if they knew that there was something abnormal about the child. So that is wrongful birth. That is where the parents claim. And the parents want the money or damages to be awarded so that that money can help them to look after the child. So the first case you will read up on will be Friedman versus Gleicksman. You will see 1996, and that was in the Western Cape. Then after that came Stewart versus Botha, also wrongful birth, and you see that went to the Supreme Court of Appeal. So in the Stewart and Botha case, they tried both. They went for wrongful birth and wrongful life. But in that case, the Supreme Court of Appeal said no to wrongful life claims, but yes to wrongful birth. Wrongful life is when the child himself, of course being represented by the parents, but the child in the child's name goes to court and say, I should never have been born. Because of your negligence, I was born and I am now suffering. So I want money to help me to have a better life. Do you see the difference? Wrongful birth, it is the parents. Wrongful life, it is the child. So in Stewart and Botha, the Supreme Court of Appeal said wrongful life claims is not allowed in South Africa because it is against good morals. contra bonus mores, against public feeling, public opinion. And they said, how can you say that it is better not to live than to live with a disability? You cannot weigh the two up against each other because life is sacred. But then H versus the Fetal Assessment Center, that went to the Constitutional Court. And it is more or less the hypothetical facts that I discussed with you. The child was already 6 when the parents got information that they could have instituted an action. In that case, the woman went to a specialist center, the Fetal Assessment Center, who are specialists, embryologists and whatever. And they made a mistake. And this child was born with Down syndrome and a lot of other illnesses. So they went first to the High Court. The High Court then said, no, the fetal assessment, the defense came and told the judge on an exception that you cannot allow this, judge, because wrongful life does not exist in South Africa. It is contra bonus mores. So the basis of their action does not exist in South Africa, and therefore you should not allow it. And then that was the High Court. And the High Court said, you are quite right. And that is where it ended. But then the parents decided they are not going to the Supreme Court of Appeal because of Stewart and Botha, where the Supreme Court of Appeal reiterated that you cannot have wrongful life claims. It is against human morals. So they realized it will not be worthwhile going to the Supreme Court of Appeal. So they went directly to the Constitutional Court. And it was argued in the Constitutional Court. And the Constitutional Court then said, okay, you can have a wrongful life claim, because it is actually the suffering of the child. You don't want the child to suffer. So you're not comparing not being born with a life with disabilities. You're trying to help a suffering child. And then the Constitutional Court said that it is now allowable in our legal system to go for wrongful life claims. It will still depend on the facts. You will still have to prove the facts. You will still have to go through a whole court case. But your basis of your action can now be wrongful life. So if we go back to that case, in other words, the parents of John, of Frans, who is now 6, now, as it is currently in South African legal system, the parents will be able to sue the gynecologist or the clinic where she had the tests done, who gave her the wrong information that the child is absolutely normal and then he wasn't. And because it's a child, he can now claim in his name on the basis of wrongful life. And then, of course, they will have to prove all the elements of a delict, etc., etc., etc. But he can do it in his name and not in the parent's name. The parents cannot anyway claim anymore. Why? Because Frans is already 6 and it has prescribed. The wrongful birth action has prescribed, because these actions prescribed within 3 years. Remember, it's the parents. They sue in their name. Frans is 6. Different rules apply. When a child is there, prescription only ends once the child becomes an adult. So he can now, the Kunenes can institute action on behalf of Frans, because he's only 6 years old, but in his name. on the basis of wrongful life. I say this, sorry, because this is quite important and you might come across a case like this, either wrongful pregnancy, wrongful birth, or wrongful life. Okay, let's carry on. Emergency. If your ground of justification is emergency, we have something in law called negotiorum gestio. That is where no consent is necessary because you are unconscious, you are in a coma or a shock, and it is a life-threatening situation. In other words, like an accident scene. Then consent is not necessary. So the emergency workers will take control of the situation. That is what negotiorum gestio mean, to take control of someone in a situation because it is life-threatening. And then they can do what they want to because they want to save your life. Let's stop there quickly. Let's say you are on a motorcycle and you have a tattoo and a bangle and there is DNA written on it. In other words, meaning do not resuscitate. And there's an accident and the emergency workers arrive at the scene. Should they leave you or not? Because you have a bracelet saying do not resuscitate. You've got a tattoo on your shoulder. Do not resuscitate. What should they do? The short answer is they should do what they can. They are compelled to resuscitate you. Why? Because they are not able to make a diagnosis. Of course, it depends on what grade of emergency worker you are. Some grades of emergency workers can, some cannot, but all over, they will not be able to make a perfect diagnosis to decide that you are going to die and therefore they can just leave you. They will do whatever is necessary to save your life and you will go to ICU. If you get there at the emergency facility of a hospital and the doctors there also see, or the emergency worker show them your bracelet of DNA or your tattoo, should they stop and not do anything further? Also a problem. The doctors in the emergency section, because it's an emergency and things go fast, they will also argue that they cannot make a perfect diagnosis, whether it is in your interest to resuscitate or not. So they will also do whatever they possibly can and they will resuscitate you. Let's say now you wake up and you are now a paraplegic. Can you sue the emergency worker and the doctor working at the emergency at the hospital because they resuscitated you and you specifically had an indication of do not resuscitate? Will you be able to sue them? No, you won't. Remember what I said right at the beginning? This more or less resembles a living will. And even though that is an indication of what you would like should happen, it is not legally binding, and you cannot sue on the basis that they did not follow your wish. Even though you have the right to self-determination, the counter-argument will be, but it wasn't a 100% fact that you would have died. They should do whatever they can. So just remember that when it's an emergency, no consent is necessary because you are not there to give consent. But the National Health, the National Health Act is very clear on when there is an emergency, no, not an accident, an emergency where there are family members. The Act prescribes who must give permission. And then, of course, you will ask the next of kin. But at accident scene, you will just carry on without consent. But if there is a possibility first to ask consent, then you do that. Now, I just want to share with you one day that I couldn't believe my eyes or what happened. Sometimes informed consent is taken a bit too far, but rather that than ending up in a courtroom. My mother was 78 when there was a lump in her breast. So she went to hospital for a biopsy. They got her informed consent to do the biopsy. So my father and I was there waiting for her. She went into the operating room. She got anesthetics, and we were sitting around there. The operation, the doctor said, will not take long, so we were just hanging around there. The next moment, the doors opened. They brought out my mother. Now remember, she already had anesthetics, so she's out of it. The doctor didn't look at me and my father. He just spoke to the nurse, and he said to the nurse, get this woman awake and get her consent. We have to remove her breast because the lump is cancerous. And he said, let me know as soon as she gave consent so that she can come back to the operating room and we can remove her breast. So there was my mother lying, a lot confused of the anesthetics, and the nurse was slapping her face and saying, wake up, wake up, wake up. My poor mother sort of came back to reality, and then she said, do we have permission to remove your breast? And my mother just said yes. So the nurse immediately took my mother back to the operating theater, and they went on. And me and my father stood there, and I couldn't believe what have just happened. They could have asked us, number one, because the National Health Act gives that right. My mother was 78. It is more dangerous to give her 2 sets of anesthetics so close to each other than just going ahead and explaining afterwards. Because a woman of 78 losing a breast, but still living, it's fine. If it was my sister of 28, that is a different story. But can you see how quickly things can go wrong? The ideal situation should have been that when the doctor spoke about the biopsy, he should have asked my mother, if he opens up the breast and he sees that it is cancerous, does she give permission for him to remove the breast? In other words, he should have anticipated and got the consent beforehand and then just carried on. But as I say, he could even have argued it was an emergency or whatever. But yeah, that was just an amazing thing that happened with a professor in medical law, and I had no words. I didn't know what to say, how to react. Fortunately, my mother came out and she is now 88, so she is still living and well. Okay, then blood transfusions. Blood transfusions you came across in the activity that you did, that Namibian case. So I think all of you are now aware that the Jehovah's Witnesses, they do not allow blood transfusions. Technology has developed to such an extent that there are alternatives for blood. I am not an expert. I don't know a lot about it. I just know that it exists. But if you are an adult of sound mind, then you have the right to refuse a blood transfusion if you are from the Jehovah's Witness faith. And it used to be like that with children as well. But the Children's Act have changed the situation a little bit. And once again, I'm giving you facts so that you can see it is not always that straightforward. Tandu is 14 and he has a chronic kidney disease. He requires a blood transfusion, which could prepare him for a kidney transplant, should there be a kidney becomes available. The parents refuse as it is against their religion. It is clear Thando will not survive without a blood transfusion. Thando speaks to the doctor and indicates that he does not follow the religion of his parents and would like a blood transfusion. What now? So the doctor comes to you. You are the legal representative of the hospital. What will your advice be? So the first thing to realize there is Thando is 14. So the lights must go on immediately. If you see above 12, red lights, Children's Act. So you will go to the Children's Act and you will focus on section 129, where it explains, according to that section, a child may consent on his own for medical treatment if he is over the age of 12, of sufficient maturity and mental capacity to understand the benefits and the risks. Unfortunately, the Act doesn't explain how do you determine that. So that will be a subjective view, whether you think Thando is of sound mind. You can look further in the same section 129. If a kidney comes available, he can even give permission to an operation, and his parents must just assent, not consent. You can go further. You can ask the superintendent of the hospital. You can go further and ask the minister. So everything is listed there in section 129. So what I wanted you to see there, 14, 14, 14, 14, that must immediately allude to you that the Children's Act come into play and you must look at it. You can also, apart from section 129, look at section 7, because the bottom line of section 7 of the Children's Act is everything that you do must be in the best interest of the child, and that also connects with the Constitution in section 28 and the National Health Act section 7, which addresses informed consent, and section 8, which gives you the right to participate in healthcare decisions. So do you see that when you are faced with a scenario like this, sit back for a minute and think and get the highlights that yes, people may refuse a blood transfusion because of religion, but then they need to be an adult. You see Thando is 14, you remember the Children's Act, you remember the Constitution, you remember the best interest of a child, you remember the informed consent in the National Health Act, and then you will be able to give advice to the doctor. And in the very, 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 very end, always remember that the High Court is the upper guardian of all children, and then you can get a court order. But it should not be necessary, and that was why section 129 of the Children's Act is there, in order to avoid a delay of asking the court to take certain decisions. Okay. Then you can also claim contributory negligence, the Doobie case. Just water. We've spoken about the Doobie case. It was that the plaster was too tight on his arm and the arm had to be amputated. And then they said, yes, but he contributed to the bad outcome. He should have gone back to the hospital earlier, but he was illiterate. He did not understand what he is supposed to feel. So he went to hospital too late. Yes, but they couldn't expect of him to know how he should be feeling And they said, no, there was no contributory negligence, and they were guilty of negligence of putting on the plaster too tight from the very beginning. Okay, now prescription. Prescription is a difficult one, and the moment you are confronted with it, you must have the Act with you and make sure whether there are any regulations or new regulations or whatever, and that you have the newest edition of the Act. Now, in the file, the loose leaf file book, Medical Malpractice in South Africa of John Sainer, Senior Counsel, it is said a debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arises, provided that the creditor shall be deemed to have such knowledge if he could have acquired it by exercising reasonable care. Once again, that is the theory, and if you understand the theory, it is fine, but it is sometimes a little bit more difficult to apply it. And for me, the Truter case is quite a sad case. The first one there, Truter versus Duisel, it ended up in the Supreme Court of Appeal in 2006. If you read that case, it is sad. It is really sad that Mr. Duisel instituted action because he had a lot of procedures to his eyes, and then eventually his one eye got blind, and he said if they didn't operate so many times, in other words, the ophthalmologist should have known by doing so many operations, he's going to do more bad or more harm than good. The problem was he couldn't find an expert to come and testify and say that doing all those operations is irregular. A reasonable doctor would not have done that. Then one day he was listening to the radio. He heard an expert speak over the radio. He contacted the person. The person saw all his medical records, and that person said he or she will act as the, I can't remember the sex of the person, will act as an expert. But then unfortunately, the court said prescription. It was, if I remember correctly, 7 years later. And then the argument was, but I could not have instituted action earlier because I did not have an expert. So how could I prove my case without an expert? And it took 7 years to find an expert. But the court said, no, sorry, prescription, it stands. Then there's another case, Lynx. And as you can see there, it is much more recent, 2016, and it is in the Constitutional Court. So that is definitely a case to take cognizance of. But the applicant was just an ordinary cleaner, and he dislocated his thumb, and it was bandaged. And when he opened it up, he saw that his thumb was amputated. And he couldn't understand what went on. And then he eventually went to an attorney, and they instituted action. And it was past the 3 years, but the court said because he was just a cleaner, he didn't understand what was going on, so they condoned it and they allowed the case to proceed. The same with Loney versus MEC Department of Health Eastern Cape was also one in the Constitutional Court. It was also one there. There was a gunshot wound in the guy's buttocks, and then he started walking crippled, and then only after years did he get legal advice that said he must sue the person, but then again prescription was claimed, but it was condoned because he did not know before that. So those two cases, because it's constitutional court cases, are worth reading if you are faced with prescription. Prescription, ordinary, 3 years. You've got 3 years for a criminal, for a civil action. 20 years for a criminal action, except that the Sexual Offences Act have changed it. But if you want to sue a doctor criminally, then the 20 years will still apply. Just remember concerning minors, prescription only commences when he or she reaches the age of 18. He or she will then have 1 year from the date of his 18th birthday in which to institute action. So normally prescription 3 years. Otherwise, go and look at those two cases, Links and Lonely, and see the arguments where prescription can be overruled. But for minors, there's no prescription until 1 year after the 18th birthday. Then only does prescription comes into play. Then just know that there is something like divisibility of damages. That is where you sue both the doctor and the hospital, and then a determination can be made according to the Apportionment of Damages Act, that, for example, the hospital is 40% liable and the doctor 60%. This does not happen so often. I mean, I read a lot of medical negligence cases, and I haven't come across this often. It is more the exception. But just know that there is something that the hospital can be liable and the doctor. Always remember that a doctor in private practice, because he is an independent contractor, and it will be a private hospital when something like that happens. But just be aware that there is an act, the Apportionment of Damages Act. Okay, so this is now sort of to summarize and the last part of your work. So remember, South Africa has a private and a public sector. We do not have NHI yet. It is envisaged for 2026 if there is money and if it is accepted by everyone. There's still a lot of infighting about that. It is actually very interesting what is going to happen in national health. It's going to change completely, and the focus will be on primary health care. In other words, there will be more clinics, and that is where one will have to start and then be referred to a general practitioner who will refer you to a specialist, etc. So, but there's still a lot of debate going on, but it's envisaged for 2026. Then you must always remember that the Constitution is in the background, the rights, the Bill of Rights. So whenever, while the client explains to you what happened, think, was the dignity violated? Was the right to self-determination violated? Was the right to life violated? So always remember that. Then you must definitely be aware of the National Health Act. You must be aware of the Health Professions Act. You must be aware of the Nursing Act and the Pharmacy Act. These are just broadly acts that regulate the profession. Just remember that the nurses have their own council, and so do the pharmacists. So under the health professions, there are a certain group of people registered there, but not the nurses. They fall under their own council. Then just take note that pregnant women and lactating women and children below the age of 6, they are entitled, according to the Constitution, to free health care. Then we spoke about this right at the beginning as well, and I said it doesn't really happen, but in cases of emergency, when it is life or death, a private hospital should stabilize a patient without medical aid cover at no charge, and then move that person once stabilized to a public hospital. Now, an interesting scenario arose in COVID time. It was a man, older man in 60s, got a heart attack. So the children drove him. They do not have medical aid cover. So they drove to the nearest public hospital. The public hospital asked them, is this in connection with COVID? They said no. They suspect, well, they did not know, but they suspected he had a heart attack. So they said, sorry, we cannot accommodate him. We only take COVID cases. So they drove to another public hospital. Same scenario. When they arrived, they said, there's something terribly wrong with our father. We think it's a heart attack. Then the staff said, is it COVID related? They said no. And they said, no, we cannot accept him. We only take COVID cases. So they became desperate and they drove to a private hospital. The private hospital took him in because at that stage he was at the point of death. So the excellent for that private hospital, they acted perfectly correctly. They took him into ICU and they stabilized him. But unfortunately, his condition was so bad that he had to stay there for 6-7 days. And then only was he stable enough to be moved to a public hospital. Because now remember, he does not have medical aid cover. And then what happened? The private hospital gave the children a bill. And they charged over R1 million for those 6 days. And then the children said, but it was an emergency. And they said, yes, an emergency to an extent, or you're still liable for the R1 million. Now, if I was the legal advisor of the children, I will not accept it. It is not their fault, nor their father's fault, that he was in such a bad condition that he was only stabilized after 4 or 6 days. It was no one's fault, and there's a duty on a private hospital to stabilize a person in an emergency who does not have medical aid, and then only move the person. Or alternatively, I will say that the state is responsible for that money because he was turned away at 2 state hospitals. The only thing is the evidence, the proof will be extremely difficult because the children was in such a state they did not take the name of the person at the public hospital who refused him entrance. And these things will be necessary in a court case, but maybe because of COVID, it could be accepted or whatever. Unfortunately, I don't know what happened then, whether the children paid the $1 million or what, but it was just a case that I heard from. But as I say, I will not accept it and pay it because there's a duty on a private hospital to stabilize a person. Whether it takes 2 hours, whether it takes 6 days, they have to. Okay, then please remember there's the HPCSA. It's the Health Professions Council of South Africa. First of all, look at the Health Professions Act, because the HPCSA is created in terms of that act, and then there's a specific code of conduct. There are different boards under the HPCSA, for example, the Medical and Dental Board, the psychiatrists have a board, the physiotherapists have a board, but you will get all that information on their website. Then they also have booklets, and in every booklet they go into detail. As I've numbered the booklets there, it might be different now because it is updated from time to time. But if you go on the website, you will be able to see the National Patients' Rights Charter. You will see what is the ethical guidelines for research. You will see what is required of doctors concerning professional development, for example, the CPD points. So you can see there's a lot. There's a whole booklet that indicates to health professionals how to keep patient records. There's on confidentiality. There's the withholding or withdrawing of treatment. So all of that will give you information to determine whether the doctor that is being accused of being negligent did in fact act negligence or not. You can measure him against all these guidelines apart from the acts. Go through the guidelines of the HPCSA as well. You can also consult the website of the South African Medical Association, SAMA, that is a voluntary association. The HPCSA is compulsory. You cannot practice as a health practitioner in South Africa without being registered at the HPCSA. So it's worthwhile going to their website. It is a lot of information that will help you in preparing your case, but you can also go to SAMA, which is not compulsory, but just a voluntary association, but there's also a lot of information that you will get there. Okay, so if you do not want to start a civil action, for example, your client doesn't have money, sorry, I'm just drinking water, doesn't have money, and your attorney's firm doesn't have enough financial backup to do it on contingency, but you do not want the doctor to get away with what he or she did, then you report that alleged negligence to the HPCSA. You can go to the website and you will see there how to report it. It is you will basically write a letter, explain everything, but the website will guide you. Also go to your website, your lead website, where you get your study material, as I've asked Bonnie to upload chapter 9 of the medical malpractice file there today. That concerns the HPCSA. That is extra information. You're not going to be tested on it, but it might help you if you have a client who wants to report a doctor to the HPCSA. It will explain to you exactly how to do it. If it's a minor case, then the ombudsman will look at it, and the ombudsman will ask for further information and take a decision. If it is worse than for the ombudsman to handle, there will be a disciplinary inquiry, whether there was unprofessional conduct or not. If there's enough information found, remember the doctor, audi alterem partem, to listen to the other side. The doctor who's being accused will get the chance to state his or her case. They are allowed to have legal representation, and then the inquiry will be done, and if it's bad enough, it will go over to a formal disciplinary hearing. It's all there in the notes that Bonnie have uploaded. I'm going through it now fast, but you can read the detail. If you are not satisfied with the outcome of the disciplinary hearing, you can appeal to an ad hoc appeal committee or to the High Court. You can also just ask the High Court for a review of the disciplinary process. And if you're not satisfied with that, you can even appeal to the Supreme Court of Appeal. And if I'm correct, this is your last activity, the Health Professions Council of South Africa versus De Bruin. In that case, I'm asking that case specifically, even if you go through the notes that was uploaded today for you to take you through the process at the HPCSA, you will see there are not a lot of cases. So this case is the best example that I could use to show you the whole process from the very beginning until it ended in the Supreme Court of Appeal. It is a sad case. It is a terrible case what the doctor did there. I apologized for the quotes in Afrikaans, those of you that cannot understand Afrikaans, but you can just skip it and you will still see what happened there. It is really, really, really a sad and terrible case. And at the end, once you've read through the case, sit back, close your eyes, and maybe for just 3 seconds, think, was it fair or not? I mean, the judgment has been given. It's many years later. It all happened in 2004. It's 17 years later. But I want you to see the process, to follow the process, what happened from the very beginning, how things went wrong, how the doctor got exposed, what happened then, what happened in court, what happened in the... So I would definitely want you to see the process, but in seeing the process, of course, you will see the facts, what the person did. And as I say, just for yourself, with your knowledge, I mean, this is the end of the module. You now know what medical negligence, medical law, medical issues is all about. Just close your eyes and for a minute, just think, do you agree with the judgment or not? Okay, then, if you are working with the Road Accident Fund, myself and Dr. Edeling wrote an article, Serious Injury Claims Rejected by the Road Accident Fund, the appeal process. It was already published in 2016. So if you are interested in having a copy of that case, you can email me and I will send you a copy, because not everyone is focusing or interested in Road Accident Fund cases. But I heard there's a lot of turmoil in the Road Accident Fund. But anyway, we wrote an article. It was published in 2016. It might help you. It's for you to decide. Then other laws. Remember, if you've anything to do, the same with children. If there's any suspicion or sense that you're dealing with a mentally ill, remember that apart from all other acts, you have to consult the Mental Health Care Act, because there's a review board through which you will work, etc. I'm not going to go into the detail as it is a specialized field, but remember that apart from the National Health Act, you must also consult the Mental Health Care Act. Okay, then there are other laws. Remember that the Consumer Protection Act is also applicable. And that is very interesting. Many years ago, it was just doctor, patient. But then as the acts came, in the National Health Act, a patient is called a user. And the doctor is the healthcare worker. In the Consumer Protection Act, the patient is actually the consumer and the doctor is the service provider. And then came the POPI Act, and now the patient is the data subject and the doctor is the responsible party. So it is synonyms for the same thing, but it is just interesting how things have changed with all the different acts. Now, the Consumer Protection Act, before the Consumer Protection Act, there's the Afrox case, and you've seen that in your study material, and I'm very, very, very sorry. That case is only reported in Afrikaans. I don't know why they did it, but if you Google the Afrox case, you will get a lot of summaries in English, but you needn't know all the facts. But what happened in Afrox is, and it still happens at hospitals, when you are admitted at a hospital, you usually sign a form, the admittance form, and there's an exclusionary clause in it that you indemnify the hospital plus the staff from any wrongdoing. So something went wrong, and the patient then sued Afrox. Afrox is was the old name for the Life hospitals. And so it used to be Afrox hospitals, it's now Life hospitals. And they said, no, 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 but you can't sue because you've signed an indemnity clause. And then they went to court. They ended up in the Supreme Court of Appeal, and the Supreme Court of Appeal said the Afrox case, sorry to the patient, the indemnity clause is valid. And that is still how the law is today, is that those indemnity clauses are still valid today. Unless someone will challenge it, but then challenge it under the Consumer Protection Act. Because when judgment was given in the Afrox case, the Consumer Protection Act was not yet in force. So we need another case that goes and claim against indemnity clauses under the Consumer Protection Act to overrule the Afrox case. But until such time, the Afrox case is the real case. Now, just again, I'm sharing something personal. So my sister had to go for an operation. So she had to be there 6 o'clock in the morning. She got the forms. She went through all of it. I saw the indemnity clause. So I drew a line through it, and I said my sister must sign next to it. In other words, sort of saying, I do not accept this. So the guy behind the counter looked at the form, see that she scratched out the indemnity clause, tore up the form, threw it in the dustbin, gave her a new form, and said unless she signs the form as is, the hospital will not admit her. So they still do it. They still have these exclusionary clauses indemnifying them. It needs to be challenged by a patient under the Consumer Protection Act. Okay, there are 8 fundamental consumer rights, and you will hear while we go through them quickly, it sounds the same as the Constitution. Everyone is equal before the law, privacy, which is the same as confidentiality, autonomy and self-determination. You can choose who treats you. In form of risk, you must be informed of the risk. The hospital is obliged to provide quality medical services, exemption of liability for loss or damage. You see why I say you have to sue again under this act. And then there's something very interesting. There's a no fault clause, or the act is no fault, which means if you get a pacemaker in your heart and something goes wrong, then you can sue the producer, the importer, the distributor, the retailer, and the doctor. You can sue the whole chain if something went wrong with the product without any of them having fault. So, I mean, the importer, he didn't make it. The distributor didn't make it. The cardiologist that planted it in didn't make it. But once it fails as a product, you have the right to sue the whole chain. That is a no-fault liability that the Consumer Protection Act have created in reliance to equipment like a pacemaker or breast implants or prosthetics that's implanted into you. If you've got a problem, then you can consult the National Consumer Tribunal or the National Consumer Commission. And then, of course, you are all aware that POPIA, the Protection of Personal Information Act, became effective in July 2020. So there is 1 year to comply. So everything must be compliant by July 2021. So it's already gone. So you have to be compliant. There is a lot of confusion. There is a lot of confusion of what is not. And in medical scenario, there's no answers yet. So at this moment, don't worry too much about this. Remember, there's anyway confidentiality between a doctor and a patient, but there need to be a code of conduct designed specifically for healthcare workers. And then another code of conduct for transplants and another code of conduct for research. But this is for the future, so just be aware, I think you all are, that the POPI Act is effective. Okay. As I said, the exercises are for yourself, so I'm going to end with an interesting case, and that is the ABC versus Thompson Medical. It is a Singapore case. And those of you who want the case can email me and I will send it to you. Why a Singapore case? Because it is so extremely interesting. The claim was instituted on the basis of contract and delict, and it is argued exceptionally well. So that is good to see. But what it basically comes down to is it is a Japanese Singaporean woman, and she got married to a Caucasian German man. They could not conceive naturally. So they went to this Thompson Medical Clinic at the hospital. It is a fertility clinic. And they took her eggs and they took his sperm and they put it in, they put it together in vitro in laboratory equipment, and then they took the embryo and they planted it back into the woman's body, and a baby was born. A perfectly young boy was born. So that was in vitro fertilization and everything went well. So a few years later, the same mother and father wanted a second child. So they went back to this same clinic and they said, okay, please, we want in vitro fertilization again. My egg, the woman, and my semen, the husband. Done, she fell pregnant, but when the baby was born and the baby came out, it was a little girl, but a very dark Indian little girl. So immediately the eyes were raised, something went wrong, DNA tests were done, and then they realized that there was a mix-up with the sperm of the husband. It got mixed up with an anonymous Indian donor. Now, what now? What now? They wanted a child, but they did not want that child. But now they have a very healthy little girl. But now the healthy little girl is not genetically linked to the father. And now what now? And how can a court decide on something? They wanted a child, they had finances for the child, they wanted a sister for the brother, everything. But they wanted a child genetically linked to the father, and they got a child not genetically linked. So on the basis of contract, the hospital were fined, the hospital and the clinic were fined. On the civil side, the delict, the embryologist, the head of the embryologist division, and the embryologist that helped with the in vitro fertilization were charged. But there was a lot of argument. How do you now punish? They were claiming, the parents were claiming the upbringing cost of this child as they would have done in an unwanted pregnancy case. But the court said you can't do that because you wanted a child. You just didn't want that child. But the court also said there must be punitive damages awarded because someone must pay because a wrong happened here. Okay. Anyway, a very, very, very excellent case, how the court argued, it was the appeal court, the highest court in Singapore, then suggested 30% of the upbringing costs must be paid as damage to the parents for loss of a genetic link. But it's a very, very, very interesting case to read. And yes, you can email me and you can ask me, and I'll send you the case. That is all from me for now. Thank you. I'm going to switch on my video now, and then you can ask questions. You can put up your hand. Just unmute yourself when you speak to me. Oh, these things always change. Let's just see. Yeah, I don't want that. No, I don't want that. Okay, let me see. I'm going to look at the conversation. Let me look at the chat box. Okay, let's just see. How will an attorney claim fees for cerebral palsy when payment is made as and when it becomes necessary or services are provided in a state institution? That is a problem. That is a huge problem. Because then how do you determine contingency fee payment? So you will have to read that cases of DZ and Machinini and see. I don't think there is clarity yet on how that should be handled, because it's now difficult to determine a sum and to pay. So sorry, I can't answer you at this stage because it's unclear. Okay, next one, to leave, you are welcome, you are excused. With regard to the two tests, remember there's only one test. There's one test, test one. That was a multiple choice, and that contributed 20%. There's no second test. Then there's a portfolio one and the portfolio two. And those two are counted together, and they contribute the other 80%. So activity 1, 2, 3 is portfolio 1 out of 150. Activity 4, 5, and 6 out of 150, that's portfolio 2. All of them together out of 300. Recalculated to an amount out of 80. Plus what you got for your test 1. Those two together is your final mark at the end. Okay, then someone say terrible is an understatement in the De Bruin case. I agree 100%. Dear madam, can I please have your email address? My email address is on these slides, and the slides will be available tomorrow. Can we please, webinar 2, the webinars are supposed to be on your website. Just go and check whether it's under announcements or additional learning material, or if you can't get it, then email me, then I will. There's no problem. You can get the slideshows, the recordings the Law Society does not make that available.
Prof, can I come in here?
Yes, please. Yes.
I wrote to the lady, and she said there was a technical problem with webinar 2, and we can't get it. So I'm a bit stressed about that because I missed the first part of the webinar. Can you just check with her?
Okay, sorry to interrupt. She said she cannot provide you with the recording.
Yes.
Yeah, I don't know. I think it's the policy of the Law Society not to provide the recordings. The PowerPoints are provided, but not the recordings.
Yeah, but even the PowerPoint is not there. So
Yeah, the PowerPoint you can get. You can definitely get. I'll check with Bonnie again whether it is on your website. Otherwise, send me an email and I will send you the PowerPoint. No problem.
Thank you so much.
Okay. Okay, the RAF case. Yes, I see. I'm going to forget people. I'm old now and it's late. I'm going to forget who asked for what. So please, I ask you to send me an email that you would like the ABC case, or you would like the RAF case, or you would like the PowerPoints, and I will respond immediately. Because once I close now, I'm going to forget. Okay, so you must please contact me. I've got no problem. And my email address is there, I think on the first, or let's just see, it's there. Just quickly go, sorry, to there. Do you see it? There, the fourth bullet, Slap M. My surname is Slabbert, so it's an abbreviation, SLABBM at unisa.ac for academic.za. And I am on my computer from 7 o'clock in the morning, and I will, all of those things are on my computer, so I will just reply to you and attach.
Thank you.
Anyone else? Just start speaking to me. I don't know why my computer is not working. My video, why you can't see me. Let's see. Oh, you can see me. You can see me. But I think you know what I look like by now. Any questions? Okay, someone say the webinar is under forums. Under webinar drop down, view full description and attachments. Okay, so look under your forums, but otherwise email me and I will send it to you. Dimakotsu, your hand is up. Do you have a question?
Oh, no. I spoke a little earlier.
Okay. I just see your hand.
Thank you.
Okay, then thank you to everyone. As I say, welcome to email me, Bonnie as well. You can ask whatever you want. We will help as much as we can. Congratulations again with your excellent results. So it's now just the last part. And once you've passed, be proud of yourself. But, just for last, this is the book that I'm talking about. It is Medical Malpractice in South Africa. You can see it's like a file. It is loose leaf. So what I've posted today is chapter 9, which concerns the HPCSA. But this, if you are a practicing attorney, you cannot go without this, because remember, I have just given you the theory, but here they give you the documents, the processes, the expert witnesses, extracts from certain acts, and it is updated regularly. So if you can get hold of this is worthwhile. This is worthwhile. Because in 3 webinars, I couldn't teach you everything. We've tried, and as I've said, this is an introductory course. But if you can get hold of, can you see there, Medical Malpractice in South Africa? If you can get hold of this, then you're going to be a good lawyer. Okay, thank you very much for your attendance. I hope I've taught you something. I hope you've realized medical law is immensely interesting, difficult, but interesting. And always just do your best, and you're welcome to make contact with me. Good night. Then whenever we meet each other, just remind me that you know me. Thank you, all of you. Bye.